There are all sorts of things people call rights: speech, privacy, getting their social security check, education. Yet only the first of these is in our Bill of Rights. So let's look at why our legal system treats all these types of claims differently, and see if we can figure out a way of classifying or categorizing rights. First, I want to warn you about a trap, about a way of thinking that's wrong but easy to fall into, and I know this because I used to have this mindset myself. I call it the Santa Claus model of the Supreme Court. This, by the way, is the Supreme Court of Canada. This way of thinking assumes that the Supreme Court gives rights like presents. More rights are always good, because more presents are good. This is deeply flawed. First of all, the courts haven't just expanded rights protections, they've also narrowed them. Second, this mindset puts undue weight on the courts, ignoring the roles of the other branches and the people themselves in protecting rights. And third, we should not make the blind assumption that more rights are always better. Every right comes with a trade-off. Giving free speech to neo-Nazis may feel disempowering to racial or religious minorities. Expanding privacy protections makes it harder for police to gather evidence to solve crimes, and so on. Few of these cases are easy. Rather than the Court Santa Claus model, I propose a different and better model: the pendulum between order and liberty. Supreme Court rulings, but also laws passed by Congress and the states, and yes, citizen attitudes towards our rights, change in response to events. After the Red Scare, we became collectively ashamed and made a commitment to protect even unpopular or subversive ideas, swinging from order towards greater liberty. After more tolerant attitudes towards crime and substance use in the 1960s, we start the war on drugs and rocket up to the top of the list of having the world's highest incarceration rates. After 9/11, we willingly trade some of our privacy for greater security against terrorism. After Edward Snowden's revelations, we start questioning the NSA's wiretapping and surveillance programs. The pendulum swings, and it swings back. So when we're talking about rights, we first draw a broad distinction between positive and negative rights. Positive and negative in this case having no connection to the meanings of good or bad. Instead, a negative right is a right against government action, freedom from government restraint. It's something they can't do to you. Whereas a positive right is something the government must provide for you, a claim to public benefits. So, quick self-quiz here. Which of the two are related to Lockean natural rights? If you said negative, you're right. The Lockean rights of life, liberty, and property are pre-existing in a state of nature, and we give our consent to a government to protect these pre-existing rights. In Locke, there are no positive rights. The government doesn't give you anything you didn't already have. Let's take an example. If we thought of education as a negative right, which is not the way we usually think of it, that would mean that government couldn't prevent us from educating ourselves or discovering or acquiring information. Now, as a matter of fact, the negative right to education does exist within our constitutional law. During World War I, there was a lot of anti-German sentiment, leading the state of Nebraska, among others, to ban the teaching of German. This German ban, however, was struck down in the case Meyer v. Nebraska. The Supreme Court found an unenumerated right to acquire useful knowledge. The government can't stop you from learning. Of course, there's no right in the Constitution to acquire knowledge, so where did the judiciary come up with this creation? Of course, substantive due process. Where do they make up all the rights they make up? Now, my guess is, none of you have even thought about education in this way because you're so used to thinking about it as a positive right. A right the government must provide to you. Well, at the national level, the courts have held that no such right exists. As far as the Constitution is concerned, the government can't stop you from getting an education, a negative right, but it doesn't have to provide you one, a positive right. The court case is San Antonio v. Rodriguez, a deep and difficult case which we'll be looking at in detail. But its holding is, in essence, education is not a fundamental right in the Constitution. At least, not in the United States Constitution, because Michigan, along with all 49 other states, all provide for education as a positive right in our state constitutions. Article 8, Section 2 of the Michigan Constitution, for example, provides the legislature shall maintain and support a system of free public elementary and secondary schools as defined by law. Some states are deciding to go still further. Plans are ongoing in New York to phase in tuition-free higher education for middle-class families, which would make higher education a positive right for many New Yorkers. How about the rights in the Bill of Rights, which are negative and which are positive? Well, let's start at the First Amendment. Congress shall pass no law restricting the exercise of religion or speech, or quartering soldiers in your home, or conducting unreasonable searches and seizures. Wait, isn't the whole Bill of Rights a limitation on government power? Yeah, basically, it is. The Bill of Rights is a classic document of negative liberty. Debatably, there are a couple of positive rights, things the government has to provide to you. You could say perhaps the right to counsel, the government does pay for a lawyer for you. The right to obtain witnesses in your favor, whom the government has to track down and drag to the courtroom for your benefit. But it's also possible to reframe these as negative rights, if you think of it in this light. Before it can take away your life, liberty, or property, the government has to give you a trial in which you can have a lawyer and call witnesses. From that framing, it sounds like a negative right. I'm not sure which is the better reading, but from that way of looking at things, all of the rights in the Bill of Rights are negative. So, if you couldn't tell, both the constitutional text and the court's decisions have favored negative rights and disfavored positive ones. Back when he was a state senator from Illinois, Barack Obama said, "The Constitution is a charter of negative liberties. It says what the states can't do to you, what the federal government can't do to you, but it doesn't say what the federal government or states must do on your behalf." Our nation has yet to break free from these essential constraints that were placed by the Founding Fathers if we're going to achieve economic justice or redistributive change. From time to time, American politicians have called for positive rights to be adopted. The most famous attempt came in 1944, when President Franklin Delano Roosevelt proposed a second Bill of Rights. Every American, he said, should have the legal right to a job, a living wage, a home, medical care, social insurance, and education. However, FDR died just a year later, and nothing came of his proposal. The U.S. Constitution, of course, is not the only source for rights. Using its Article 1, Section 8 powers, Congress has created statutory positive rights, that is, positive rights enacted by law. The entitlement programs, welfare, Social Security, Medicare, Medicaid, are notably among these. Which takes us to the major due process case, Goldberg versus Kelly. Again, the government doesn't have to provide welfare rights, it doesn't have to provide you an education. But once it does, the court ruled, it can't just cut them off without due process. Once the government establishes a right, it's treated as part of an individual's property. Just as the government can't take away your traditional property without procedural due process, neither can it terminate payments. Other types of government-created benefits are treated similarly as property, such as licenses, like for driving or occupational licenses, jobs in the public sector, and a public education, which is why when a student is expelled from school, there needs to be a hearing. The government can't take away your life, liberty, or property without due process. Does that mean that it has an affirmative duty to protect them? In other words, do you have a positive right to safety in the protection of your body and your possessions? Remember that positive rights are disfavored in our system, and I think you'll know the answer to the question, which unfortunately involves a 4-year-old kid. Little Joshua DeShaney was regularly beaten and abused by his father. Joshua's mother, recently divorced from this beast, repeatedly contacted social services of Winnebago County, Wisconsin, trying to get and enforce a restraining order. Social services essentially did nothing, and one day Joshua's father beat him into a coma, causing him irreparable brain damage that halted all mental development and would leave him at the mental age of a 4-year-old his entire life. Does Mrs. DeShaney have a constitutional case for suing the county for depriving her son's due process? No, says the court. Due process is a limitation on a state's power to act, not a guarantee of certain minimum levels of safety. It does not impose an affirmative obligation on the state. In other words, a negative, not a positive right. This case became known as the Poor Joshua case, based on the first line in Justice Blackmun's emotional dissent. Poor Joshua.